we're going to talk about the FMLA. Yay! Yay! Everybody loves Back to the Future and the FMLA. So what a great pairing. Oh, there we go. Oh, wow. That wasn't supposed to look like that. Anyways, we just came from August 5th, 1993, when the FMLA became effective. We're starting here in October 20th, 2016 at 1:35, and we're moving forward into the future till October 20th, 2016 at 1:55 p.m. when you will understand all of the common pitfalls that occur at the beginning of FMLA coverage, which is what we're going to talk about today. So, this is our roadmap, but in the words of Doc Brown, where we're going, we don't need roads. We're going to talk about covered employers, eligible employees, and some of the initial paperwork that really starts off the FMLA process. And I'm going to focus here on things that I think are common errors that are made in your FMLA programs and easy ways to fix them. All right, so let's start with our covered employees. And this list should look very familiar to anybody who has ever looked at the FMLA. Employers with 50 or more employees and 20 or more work weeks in the current or preceding year are covered employers for purposes of FMLA. But I'm going to break these down a little bit for you because not everybody understands exactly what's included in each of these elements of FMLA coverage. So let's start with our employee count. 50 or more employees. And for purposes of FMLA, an employee is any individual employed by an employer. Really, really vague. So the FMLA could possibly apply to a lot of different people. It includes all of your full-time employees and all of your part-time employees. We know that. Also includes your seasonal employees in the count. And in case you didn't know, you also have to include your temporary employees in the count. That might be surprising to a few people. When you're counting employees for FMLA coverage, you also have to look at employees who are on the payroll, regardless of whether they were actually paid in a work week or not. So if you have an employee who is on the payroll but not working that week, you still got to count them. You also have to count employees who are on paid or unpaid leave, including FMLA leave, disciplinary suspensions, or other kinds of leaves of absences, if there is a reasonable expectation that they will return to work at some point. Unpaid volunteers and workers outside of the US, you do not have to count those. So they do not get counted in your 50 or more employees. Something else that might change your count is whether or not you're an integrated employer. And the FMLA looks at businesses as a whole as opposed to separate subdivisions. So you may be an employer where you have one part of your entity operating in Ohio and another part of your entity operating in New York. But it could be that both of those entities are integrated for coverage purposes. If you have common management, I can't read my slide from here, interrelation between operations, if you have centralized control of labor relations, such as your HR department is at your company headquarters, and you report to your HR department from Ohio to wherever the company headquarters is, you might be an integrated employer. And in that instance, you account all of the employees in the integrated company, not just your separate subdivision. And the FMLA was set up this way so that employers didn't break up their businesses into little pieces to get away from FMLA coverage. Joint employers, this probably will not increase your count, but if you are using temporary employees or if you are using a PEO for part of your business operations, you might both have to count an employee. So an employee might be counted on both sides, both on the staffing agency side and on the side of the secondary employer. So it won't increase your count, but it may double count an employee, and that's okay. And then successor employers. This would apply in a situation where you have a business that was sold. And perhaps the business was sold, June 1st. And on June 1st, there was only 49 employees and 49 employees going forward. But under the prior operations, which are substantially similar to what you're doing now, there was more than 49 employees. And there was sufficient employee counts for the past 2 years to enact FMLA coverage. In that kind of situation, simply because you purchased a business and you're new to operating, it doesn't mean that you can just do away with FMLA coverage. If you are in a situation where you've purchased a company, you may have to continue FMLA coverage until your counts are below 50 for the certain amount of time that's necessary. And the time that we're looking at is 20 work weeks in a year. The important thing to note here is that the 20 weeks do not have to be continuous. You can have a couple weeks at the beginning, a couple weeks in the middle, a couple weeks at the end. As long as they come up to 20 weeks in a year, there's your 20 weeks. But to be counted on this end of the equation for employer coverage, an employee has to be working at the beginning of the week and at the end of the week. So if you have an employee who was working at the beginning of your work week on Monday, they get fired on Wednesday or they quit on Wednesday, they don't count under the employer side of the calculation. So it's only employees that are employed both at the beginning and at the end of the week that are included in your 50-person count. And in the current or preceding calendar year, you're going to look at this not only for initial coverage for employers, but also if you ever want to remove FMLA coverage. So if at some point you go from 50 or more employees down to 49 or less, you have to do that for 2 years, 2 consecutive years. You can't just automatically take off FMLA once you get below 50 employees. On the employee side, there's things that the employee has to do to be eligible for FMLA leave, and these should look familiar to you as well. Work for a covered employer, work at least 12 months, accrue 1,250 hours of service, and work at a location with 50 or more employees. Now, the covered employer we just did. So if you understood that, you got this covered. And if not, you can see me afterward and I'll help you. The 12 months of service. This is not continuous. There can be breaks in employment. If you have somebody who works for you seasonally, maybe they only work a month or 2 out of the year, but they keep coming back year after year. If they build up 12 months of service, they could qualify for FMLA coverage. And on the employee side, any part of a work week that they work counts. So if they only work 1 day a week, it counts, as opposed to on the employer side where you only count whole weeks. This you can count partial weeks. And any combination of 52 weeks will get you to coverage under this specific element. Now there is an exception to this. Well, this isn't really an exception, but breaks in employment of more than 7 years, you don't have to go back any further than 7 years to count FMLA coverage. So if you can't get to 12 months within 7 years, then you don't have to look any further back. And that's a break of 7 years. If you have somebody who's worked, I can't even imagine a scenario where you would have a 7-year gap, but in the event that you do, you don't have to look back any further. Unless, and there is an exception to this exception, unless the break was for USERRA purposes, and Tybo is going to talk a bit about USERRA later, or your collective bargaining agreement allows for it, or you have a policy that is uniformly applied where you can look back further than 7 years. This is one of my favorite scenes in the movie, of the second Back to the Future. And I'll read it to you because it's really hard to read in the slides. And it's Marty McFly. He just arrived in the year 2015. And it said, he's reading a newspaper where his son, Marty McFly Jr., has been arrested. And it says, within 2 hours of his arrest, Martin McFly Jr. was tried, convicted, and sentenced to 15 years in state penitentiary. 2 years? Marty asked. And Doc says, yeah, the justice system works a lot more swiftly now that we've abolished all lawyers. One of the best scenes of the movie. Okay. Eligible employees need to have at least 1,250 hours of service. And this is within a 12-month look-back period from the beginning of their FMLA leave. It's not a 12-month calendar year, but it's a 12-month look-back period from whenever the FMLA is going to start. So if you get an application for FMLA leave and they anticipate that it's going to start 30 days from now, you have to account for those 30 days and the hours that you believe are going to be worked in that 30-day period when you're doing the look-back. And you're only going to count time actually worked. You will not count paid sick time, paid vacation, other forms of time off, but only hours actually worked. And it doesn't matter, full-time, part-time, seasonal, temporary, everybody has to meet this 1,250 hours of service requirement. You calculate this for each leave request. And it's your burden to maintain accurate time records. It is not the employee's burden to prove that they have 1,250 hours of service. The last element for the employee side of coverage is to work at a location with more than 50 employees. And this includes not only the specific work site that they're at, but also any work site within a 75-mile radius. And I'm going to talk in a minute about how to measure that. If you have an employee who works at home or works remotely, their residence is never considered their work site. It would be whatever office they report to, they are given assignments from, or they are assigned to, but it's never their home. So you could have an employee who is assigned to the Toledo office, but they actually work in Tulsa, Oklahoma. So when you're determining whether or not the work site has 50 employees, it's all the employees who are assigned to the Toledo site and 75 miles around it. Or where the work comes from. There you go. And when you're counting the employees at the work site, you count everybody, including seasonal and temporary employees. Now, for measurement purposes, the 75-mile radius is not as the crow flies. It's not a circle that you can just draw around the location and say everything within this circle is 75 miles away. But you have to use the most common or the most direct method of travel. I'm going to give you an example. We have an office in Port Clinton, not we, but in our hypothetical, we have a Port Clinton office. And there's 30 employees at Port Clinton. The next closest job site is in Ada, Michigan, pretty darn close to 75 miles away, where they have 20 more employees. So that would get us to our 50 within 75 miles if it qualifies. If you go onto Google Maps, you see that there's a couple different ways you can measure the driving distance between the two. And I know that nobody ever does this, but if you're submitting mileage reimbursements to work, and there's a couple different ways you can go, you almost always use the longer route because it's more convenient for you. But you can't do that for FMLA purposes. You have to use the most direct route. And I'll tell you that if the most direct, commonly used route is either by air or by boat, you have to use that as well. So there is a route that is more direct that gets you there in 74.8 miles. Therefore, your Ada, Michigan site is within 75 miles and it needs to be counted. Okay, a little bit about paperwork. There's a lot of paperwork involved in FMLA coverage. I'm going to cover two of the forms that I see a lot of errors on, hopefully so that you don't make the errors that I've seen other employers make. And these two documents are right behind my PowerPoint presentation in your handouts. The first one is the Notice of Eligibility and Rights and Responsibility. This is actually two different notices that have been combined into one handout by the Wage and Hour Division, helpfully so that you can just hand out one sheet and be done with it. The first section I want to draw your attention to is in the middle of that first page, and it's where you notify the employee about their eligibility for FMLA leave. You need to check one of the first two boxes. You either need to tell them that they are eligible or they are not eligible. If they are not eligible, you need to make sure that you check one of the following boxes for a reason that they are not eligible. And remember that it is your responsibility to maintain records to demonstrate that they are eligible or ineligible. So if they're ineligible because they don't have 12 months of service, you need to make sure that your file has sufficient documentation. And if your employee comes and asks you, well, what is my status? You can tell them, well, you've only worked 50 weeks. So that's your responsibility. Make sure that you are accurately stating why they're not eligible. If there's more than one reason, check more than one box. The second part I'm going to draw your attention to is at the bottom of the page. It's the part B, rights and responsibilities. You'll notice that the first checkbox is requesting additional certification. We're not going to cover certification in this presentation. I think we could talk about that for at least half an hour all by itself. But if you don't have certification, make sure you're getting that form to your employee and make sure you let them know that you don't have it, because they have 15 days from the time that you give them notice that you need certification to provide it to you. And then there's the second box down there is sufficient documentation to establish a family relationship. There are certain kinds of family members where you can take FMLA leave for their care. A son, a daughter, a parent, or an adult child who is disabled. You can also take it if you are in loco parentis of a child or a disabled adult. So proving that you're a son or a daughter or a parent may not be difficult, but proving that you're in loco parentis might have a little bit of documentary challenges. The FMLA does not require that you prove family status, but as an employer, that's your option to do so. And if you want to require employees to prove their family status, you need to do that uniformly across everybody. And for in loco parentis, which I've heard Tybo talk about many times now, where you're caring for a person, a child, or a disabled adult who is not your own child, but you act as their parent, perhaps providing a signed statement or a signed affidavit to that effect would be sufficient for your purposes. So just be prepared for those situations. Moving on to the second page of this rights and responsibilities, and there are two facing pages for you in your book, so that's very helpful. At the top of page 2, there's a box where the first checkbox provides a line for you to provide contact information for the person in your office who makes arrangements for payment of insurance premiums, premiums while they're out. If you are requiring employees to pay their insurance premiums while they are out on FMLA leave, and I think that most of you would, you need to let them know who they can contact to make arrangements. And then you need to make sure that that person is monitoring that they're actually receiving the payments. Because you don't want to be in a situation where you've had an employee out on leave where they were supposed to pay the medical insurance, but they haven't paid the medical insurance and they've continued coverage. So make sure that whoever's monitoring that is doing so and is collecting payments regularly. The second box is really, really important. If you want your FMLA leave to run concurrently with any paid leave that the employee has available, you have to notify them, and this is your way to do so. You don't have to require it, and in fact, if you don't notify your employee that you're doing it consecutively and they don't ask for it to run consecutively, then it won't run consecutively. You could have a situation where you have an employee out for 12 weeks on FMLA leave and then come back and then take their 2-week vacation to Disney World. That could happen unless you designate that their time has to run concurrently, then they'll get paid for the first 2 weeks that they're on FMLA leave, which they might really appreciate anyways. And then the third box, the key employee box. You are allowed as employers to designate key employees. Key employees are people that are paid on a salary basis, and they're within the top 10% of the earners at your location. And if you designate somebody as a key employee, you're letting them know that their position is so important to the organization that it may not be available when they come back, because you can't leave it open for 2, 4, 6, 12 weeks. And so if you're designating somebody as a key employee, make sure that you're doing it there. There's one other notice, and this is the designation notice I've included. And there's just one thing I want to point out there. There's a box in the middle that again says, if you are requiring paid leave to run concurrently with FMLA leave, that you designate it. And so you need to do it in both places. Just dot your T's, cross your I's, have it designated in both places so that there's no question later on about whether or not this leave runs concurrently or not. Okay, that is all that I have for you on the FMLA today. I do want to let you know that the Wage and Hour Division has a really handy guide on their website. It's quite thick, as you can see, but it is comprehensive. It came out within the last 6 months or so. And if you are an administrator of your FMLA coverage and you haven't already taken a look at this, printed it out, tabbed it on your desk, I would recommend you do so. All right, thank you very much.